Appeal for the 5th District of Florida is now in session. Honorable William G. Palmer, Chief Judge, presiding. All persons saying business for this court draw your due attention and you shall be heard. Thank God the United States of America. This honorable, you may be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've heard, I'm Judge Palmer. To my right is Judge Lawson. To my left is Judge Evander. We have both criminal and civil cases on the docket today. Criminal cases get 15 minutes for each side. Civil cases get 20 minutes for each side. The appellant can reserve as much of their time for rebuttal as they choose. We have 3 cases scheduled for 9 o'clock, 1 scheduled for 10:30. We will take a break at some point, at which point any of the lawyers who are interested can join us in the lawyer's lounge for coffee. The first case on the docket is PREMO versus State.
May it please the court, Jerome Rotenberg for the appellant. This is a case involving a violation of probation. And it's our contention that the trial court abused its discretion by finding that there was a willful, substantial violation of a material condition of the individual's probation. And of course, it's well established that in order to find the violation, the evidence must establish by a greater weight of the evidence that the appellant deliberately and willfully violated a substantial condition of the community. He was actually on community control rather than probation.
Is it your position it wasn't willful, or it wasn't substantial, or it wasn't either?
Substantial.
All right. Are you contending also it's not willful, or are you saying it was willful but not substantial?
It wasn't willful or substantial, and of course we do cite a case to the effect that if it's negligent conduct, then it cannot be a willful, substantial, knowingly violation of the condition. And here, of course, the main thing that I think the court should also consider is the fact that these were not violations of any criminal acts. These are merely technical violations. Of course,
Isn't the entire point of community control with electronic monitoring that the state knows exactly where the defendant is at all times?
I'm sorry, I have a little difficulty.
I said, isn't the whole point of community control with electronic monitoring to allow the state to know where the defendant is at all times?
Yes.
So why wouldn't it be a substantial violation if the defendant puts himself in a position that the state can't track his whereabouts? That would seem to me to be substantial.
Well, if it's a willful violation, I think, however, the evidence here showed
So you would concede that
it's not necessarily.
So are you conceding that it is substantial?
Yes, under the law, I
Okay.
would think so, especially in view of the fact that in Florida, the courts have even held one failure to report for a violation. For probation report is a violation of the conditionless probation, regardless of how well the probationer was doing on his probation. And of course, but I think the court should take into consideration in here the fact that, number one, the individual did testify that on one of the occasions, the time that he was so-called untrackable, he was actually sitting in the probation office waiting to be interviewed by his probation officer. So there was no question that he was around. And then he also testified that in response to one of the calls, he did put his cell phone into the cigarette lighter of his automobile, but for some unknown reason, it shorted. And there was no evidence presented by the state to refute that evidence. The probation officer testified he never investigated the cigarette lighter. I think he said something to the effect he wasn't on it when asked on cross-examination whether he investigated it. He said, no, I'm not an auto mechanic. Well, it's a situation that was not willful. He was unable to keep in contact with the probation officer because of some unforeseen circumstance. And the one case that we do cite in the brief, Stevens, has to do with the negligence. And there the individual was found guilty of violation of probation because he didn't attend a mental health class. And one of the reasons he said that he didn't attend it was because his car broke down. It was something beyond his control. And here, especially, we look at what the goals of probation are. They are to rehabilitate the probationer, protection of society from future criminal violations, protection of crime victims, and rights. And here, the conduct of the probationer had nothing to do with those three goals. He was, had he been cited for some type of criminal violation, be a different situation, but it wasn't. And also the cases hold that the violation must be such that there is an indication that probation will not work for the individual. But here the evidence showed that it was working. In fact, his own probation officer said on April 23rd, was several days after these violations, that he had no intention of violating the probationer. So evidently in his mind, it probably was not of such serious nature that he should have been violated and sent to the Department of Corrections for a long period of time. And one of the charges, of course, was that he failed to return a call to the on-duty probation officer. And there she testified that she had called him at 6:15 in the morning to report that the system, I think that his system wasn't close enough to the transmitter, and he never called her back, but within 14 minutes afterwards, she testified that the system was working okay. And of course, the failure to charge the unit, he said he thought he had plugged it in, but evidently perhaps it wasn't working right, and he did mention that on occasion he had made complaints to his probation officer, something about the pins that are in the unit. I didn't quite understand what it was, but the pins weren't working properly. And in fact, several days afterwards, he was given a new unit. And of course, the people from the manufacturer, ProTech, said that they had not received the unit yet from Citrus County, and consequently they never had an opportunity to examine the unit to see whether or not there were any defects in it.
Let me ask you about this lack of a return phone call. Now, the fact that the unit, the bracelet got back within range 15 minutes later, don't you think it's reasonable that the probation officer or the person monitoring the system would want to know what caused the problem in the first place? I mean, would that be a legitimate question?
That he called back?
I mean, you know, the fact that the system was working again 15 minutes later is not the end of the inquiry. Yeah. Would you agree with that?
Well, evidently he plugged it in, or it wasn't plugged in before, or what have you, but he received the call on his voicemail.
Well, how would the probation officer know that if your client did not return the phone call?
Well, they can tell that it is working from the various monitors that they have, and
but they knew it was working 15 minutes later.
Right,
but how would they know what was happening previously when they got the bracelet gone along?
The only way to find out definitely would be by investigation and asking him what had happened.
Okay, and if he doesn't return the phone call and he doesn't give a reason for it, is that willful?
Well, I believe his reason was that it wasn't working properly.
Right, but did he ever testify as to why he did not return the phone call?
Yeah, he testified, and he said that he had it plugged in, but as far as not returning, I don't believe he said that the reason he didn't call back was because it was then working properly. I do not recall seeing that in the transcript. I was not the trial court attorney. Okay. However, However,
What wasn't the state's evidence, didn't the state's witnesses testify that your client was instructed that if the on-call officer ever called him, it was a requirement of probation that he call back?
Right.
Immediately?
Yes.
Okay.
Right.
And he didn't do that, correct?
No.
Okay.
Well, then there was something brought out in the trial court that I guess the actual instructions say that he must return calls on the tracking machine that he receives on the tracking machine immediately, whereas here this was a call on his cell phone. So it's a question of whether or not technically there was a violation. Of course, there are some cases to the effect that the probation officer cannot himself deviate from the standards of community control or probation. However, once again, though, and also the amount of time involved, on the other occasion, they brought out the fact that he was so-called out of the system, but there his logs were proper, and it showed that on that particular evening, he was at Baycare receiving his therapy counseling that was a condition of his community control. So therefore, it isn't a situation where he's out wandering on the street somewhere. And as a result of that, I do not believe that the state did prove its case by showing that there was a willful, substantial violation of the conditions of probation. And the yellow light goes on, so I guess that's the end.
You have 5 minutes left if you want to save some or all of it
Can I
for
reserve
rebuttal.
it for rebuttal?
All right.
Okay.
May it please the court, my name is Wesley Height and I represent the state on this case. The issue before us is whether the violations below were willful and substantial. There was a testimony as to a series of violations. I'd like to quickly summarize 3 of those. The first was the defendant was specifically told to charge his unit 8 to 10 hours a day. On April 16th at 9:18, the unit went off charge. Over 30 hours later, post 5 o'clock on April 17th, it was placed back on charge. That's clearly a violation. The defendant's explanation when asked was, I was too sick to charge it. Secondly,
And that was not his trial testimony, correct? At trial, he claimed that he did try to charge it, so he changed his story between what he told the probation officer and what he told the court. Is that correct?
Correct. He, at trial, testified the machine potentially was not working properly, gave various testimony as to the pins. The officers testified before the court that they went at least once a week to the defendant's house. The unit was always tested and always worked properly. The officers also testified that they got the unit afterwards, subsequent to the violation, and tested the unit and it worked properly. So, in fact, they even put on a demonstration for the trial judge and had another unit there, and he showed the fact you can't hook it up without it charging. It almost can't place it into the unit without it charging properly. So that was covered. Additionally, there's testimony as to he was about 6 o'clock in the morning. The bracelet was too far from the unit. It went off. About 20 minutes later, it gets close enough and the alert is cleared. However, the officer called and specifically said, this is Officer Zelna. You need to call me back. And he was instructed, when you're told to call back, call back. He testified at the hearing. I never called back. Stated that at least twice at the hearing. Clearly a willful and substantial violation. He's offline the next day on 4/17 for about an hour and a half. The unit goes dead because he didn't charge it, and again, willful and substantial. So we clearly think we proved that. This is probation and community control or grace of the court, and he violated the terms of that agreement. If there are no questions, thank you.
Thank you, Counsel.
There isn't much to rebut. However, I think once again the court should take into consideration how the probation was working for this individual. And here the officer did testify, that is his own personal probation officer testified that he never had any trouble getting hold of him. that the probationer was working, which is a very essential element of probation. He was going to his therapy as required by the conditions, and also the fact that he was keeping a good driver's log, which at all times shows where he is, how long it takes him to go from one point to another. And in considering all of those factors, I believe should be taken into by the court in determining whether or not there was a willful violation, or was it because he wasn't fully able to work the system. I know I myself, I'm always getting complaints from my office, I don't have my cell phone on. And also, I don't know how to retrieve messages or things of that sort. And here the machines are complicated. And the machine, first they were using one system, iSecure system, and they decided they weren't using those anymore, and they went to ProTech. And the people from ProTech did testify that the machine has difficulty tracking a person when the person is indoors. And of course, that also could account for that one long lapse where he was out of circuit, where he claims he was in the probation office. But nobody denied that he was not there. And all in all, based upon the evidence presented in the lower court, that this court should reverse and remand and reinstate him to probation because the state has not proven a willful, knowing, substantial violation of his conditions. Thank you.
Thank you, counsel.
Thank you.